Swayam Prabha. Digital India. Educated India.
Dear students, we already talked about cartelization and one of the anti-competitive practice, and this class we are going to talk about bid rigging. And you may be heard about bid rigging, but the presently all the government purchases or other purchases are used by the online bidding. And bid rigging is considered to be again which is anti-competitive in nature, and we will see that how it is anti-competitive, why it is anti-competitive in nature. Because bid rigging and what is the purpose of this bidding? The purpose of bidding itself is to get best prices. You purchase best prices on best prices, and that is the bidding is required. So, that the different producers can offer different prices for these similar goods which we want to purchase. And the bid rigging, the entire bid rigging process which vitiates the entire process of this bidding itself. And it means the bid rigging means that any agreement between enterprises or persons engaged in identical or similar production or trading of goods or provision of services which has the effect of eliminating or reducing competition. So, ultimately bid rigging which have a directly impact on eliminating competition or reducing competition in the market is considered as anti-competitive in nature. And there are different forms of bid rigging, that is one is bid suppression, that is all the people is refrain from bidding, so that any one of them can bid for the same. And secondly, complementary or cover bidding, these are submit too high, that is you are submitting bids at too high prices with unacceptable terms. So, that you go to the negotiating table and negotiate with them, and they fix the prices. And thirdly, bid rotation, and these are competitors agree to take turn one by one as the lowest bidder. So, this time, so I will be the lowest bidder, the next time you will be the lowest bidder. There is an arrangement like cartel, there is an arrangement between the suppliers for the lowest supplying or lowest bidder. Then subcontracting, that is if there is a collusion between the competitors and they get subcontracts from the successful bidder. So, you go for the bidding, and we will also get a pie of the entire cake, that is subcontracting. And all these are considered to be the pernicious to the market and also to the price effect. And bid rigging is explained in section 3 of the Act. It defines as any agreement between enterprises or persons referred to in subsection 3 engaged in identical or similar production or trading of goods or provision of services which has the effect of eliminating or reducing competition for bids or adversely affecting or manipulating the process of bidding. So, it simply the definition which says that it is an arrangement between a group of people for fixing the prices. So, bid rigging in a collusive tendering is the practice the firms agree themselves to collaborate or cooperate each other along with the tenderer. So, you can see that we were not going to the cases, but it is always there is a again like cartel, there is a collaboration or agreement between the participants of the bid in this as well. And some of the factors are the mentioned by the US Antitrust Division very clearly, that is fewer sellers as it is easier to collude. If few number of sellers, then it is easier to collude, it is in the bid rigging. And then if the products are not so easily not substitutable also, they can rig the bid. Then again, highly standardized product, easier to agree on a common price. Then again, repetitive purchases involving the same firms, as bidders become familiar with each other, and future contracts allow competitors to share work easily. So, these are some of the examples of factors favoring bid rigging and favorable to the bid riggers. And also the again the US Antitrust Division has set some illustrative indications of this. So, the same company always wins a particular procurement contract, and they win it, and then they can go for rotation or they can go for subcontracting, and the same suppliers submit bid on each company seems to have take turns. So, which we talked about, they take the turns and then on the higher prices from time to time. Then the bid prices drop whenever a new or in these infrequent bidder submits a bid. So, then so that they can eliminate that new bidder and they can continue with the bid rigging process. And then there are irregularities, for example, identical calculation, or the identical calculation, spelling errors, handwriting, and now is the computer is used. So, there is no question of identical handwriting, but the same kind of forms were used, and also all these are have a suspicion on the bid rigging, which leads to these are the evidences of bid rigging, which we can look upon. And then bid rigging, how the process takes place. So, it is, as I told you, the bid rigging are always an agreement between a group of bidders to eliminate competition in the India procurement process of any goods, and ultimately fix the prices. And definitely the prices will be going to be very high, because then only they can make the maximum profit. So, then again one competitor he submit the bid, and the another one agree to submit a non-competitive bid which is too high and or which is unacceptable to the buyer. Then again his competitor agrees not to bid or to withdraw a bid from the consideration, and this is also part of bid rigging. Then again the competitor agrees to submit bids only in certain geographical areas or only to certain public organizations. So, that they divide the public organizations, and you submit in these public organizations and I will submit on these public organizations, and they divide amongst themselves these particular organizations, so that they can always fix the prices. Then also the and they have one thing common, the bidders agree to eliminate competition and fix the prices. These are the two conditions which is always there in the any kind of bid rigging. And then again it is illegal in most of the countries, the price fixing and market allocation is illegal in almost all the jurisdictions. And the collusion of firms in procurement and bidding, and this is in a always a predetermined level, and they collude each other. And if you look into the forms of bid rigging, you can see the bid rigging may take in different forms. They may be bid suppression, and bid suppression schemes which include these, you can see that. So, you see one or two bidders who are supposed to submit their bid or previously bidded, and who is there is a most chance of getting the bid, he agrees to refrain from the bidding, or he is withdrawing from previously submitted bid, so that the designated winning competitor bid will be accepted. So, that means even though this lowest bid is submitted, later on they come to an agreement that the other people will withdraw from the bidding process, so that a particular bidder can get the bid in favor, and so that they can fix the prices. The second category is the complementary bidding, and complementary bidding is to cover up, it is a courtesy bidding, and to cover up the main bid. That means the competitors agree to submit that it seems to be there are bidders, competitors, but actually there is no competitor, because even though he submit the bids, he put very high prices which is not acceptable to the buyer, and at the same time it is not a genuine bidding which is given. So, the complementary bidding is not going to be genuine at all, it is always going to be very high prices which is not acceptable to the purchaser always. And these this is one most type of rigging, because it seems to be that there are bidders, but actually these are bid rigging. As so, they can defraud the purchases by creating various barriers to this competition and inflate the prices. So, that simply there is a group of bidders, they bid, actually there is a lot of bidders, but there is actually one designated bidder because of this complementary bidding or bid rigging. And then bid rotation, which I already talked about. The rotation, in rotational schemes all parties participate in the bidding, but always the lowest bidder will be the designated person. So, that the next time the another person can be given this particular, it can be given to the other one on rotation basis. The objective is very clear, there is nothing but to fix whom to be given the bidding, who is going to be the bidder, and always also to fix the prices. Then another form is the market allocation, and the market allocation is always, it can be territorial allocation or a particular market allocation. So, for example, the Indian market is divided into maybe to south, north, and then east and west, and the company, one company is designated for one region and another company is designated for another region, and this is also considered to be, the market allocation is also considered to be a bid rigging process. And market allocation can happen, and is basically to it is sheltering from competition, because this particular market I have an advantage of various kind of advantage. So, that you do not bid this, you give me this particular region and you operate in that another region. So, he may not have any production of goods in that particular area, and also he is not going to sell that particular product in that particular geographical territories, and not soliciting or sell to the existing customers each other, not to disturb the customers by the competitors. So, there is an agreement among the suppliers not to disturb the market, not to disturb the regionality, not to disturb the existing customers, and this is known as the market allocation, and market allocation is also considered to be is a part of bid rigging. Then another form which you can see is the output control and limiting production is also considered to be, is absolutely considered to be the illegal per se rule. So, the per se rule will be applicable. The exemptions which you can find is the joint ventures, and the horizontal agreements and all horizontal agreements have been considered to be per se is considered to be harm to the competition and thus illegal. So, the exemption is offered to one category of association, that is known as the joint venture, is in order to enhance efficiency, but this is not an exception actually, and they have to show certain advantages to the society and ultimately to benefit the society, ultimately to benefit the consumers, then only these exemption can be applicable. And then the such essentials. So, the enterprise, if the enterprise can show certain advantages, then only it will be exempted from this kind of these anti-competitive practices. Then usually intellectual property, which we will discuss when we discuss about intellectual property versus competition. So, under section 3 also intellectual property protection is exempted from the competition provisions. And export cartel exemptions. So, here again the Act also provides the restrictions relating to anti-competitive agreements, cartels. So, in the case of exporting goods from India, to the extent the agreements relating to exclusivity production, supply, distribution and other things, because the other countries will take care of the competition issues in their markets. And the leniency regime, and there is a provision in the Indian Act which also the CCI provides the leniency regime for the enterprises. This is nothing but the Competition Commission imposes a lesser penalty based on the regulations in 2009, those who cooperate and those who share confidential information and data with the Competition Commission. So, according to this provision, so any one of these cartel participant can cooperate with the Competition Commission of India and provide informations, and so they will be punished less under this leniency regime or leniency regulations of 2009. And the leniency regime, which you can see that the penalties, the applicant should not have any further participation, that in certain conditions to be fulfilled for participating in this particular program, and they should not be any more with the cartel. And then again the second condition, and information provided by the member of the cartel should be vital disclosure. And thirdly, the applicant should cooperate to the completely cooperate to the extent, the fullest extent they should cooperate with the Competition Commission of India, and the relevant evidences should not be concealed, destroyed or manipulated nor removed by the applicant after they participate in the leniency program. If all these conditions are fulfilled, they can participate in this program and get a lesser penalty when compared to the other participants in the cartel program. So, in this particular class, I try to explain what is bid rigging. Another is one of the very common anti-competitive practice, and the first we discussed about cartelization and different cartelization. This class is on various forms of bid rigging, a common form which is adopted by the business enterprises. So, bid rigging is also affecting, ultimately the purpose of bid rigging is also to fix the grant of bid, as well as fix the market, fix the prices based on markets, regionality and other conditions. So, this also will always affect the market, and ultimately it is harmful to competition, it is harmful to the consumer interest. So, it is anti-competitive in nature. And so, the anti-competitive agreements which we discussed about is completing, and then in the next classes we will go to the abuse of dominant position and other activities which are prohibited under the Competition Act. Thank you.